As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
25 states have joined a lawsuit with the NRA going against the ATF pistol brace rule.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity, which the United States Congress did.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
The Supreme Court just shattered the hopes of millions of gun owners across America, and the implications are far more devastating than anyone realizes. Two landmark cases that could have revolutionized firearm ownership nationwide were crushed in a single morning. But what happened next is where this story takes an unexpected turn that nobody saw coming. This morning's Supreme Court order list contained two denials that sent shockwaves through the Second Amendment community. The cases of United States versus Rush and the Robinson Challenge weren't just rejected, they were dismissed without explanation, without dissent, and without hope for immediate appeal. These weren't ordinary legal challenges. They were emergency applications begging the court to intervene in what has become a constitutional crisis affecting every gun owner in America. The timing of these denials reveals something deeply troubling about where gun rights stand today. Just days after refusing to hear challenges to machine gun regulations, the same court that supposedly champions the Second Amendment has now abandoned short-barreled rifle owners to a legal nightmare that defies logic and constitutional principles. What makes this denial particularly shocking is how the lower courts have been treating these cases. The Seventh Circuit Court didn't just uphold restrictions on short-barreled rifles, they declared these firearms have absolutely zero constitutional protection. Think about that for a moment. A federal appeals court just ruled that an entire category of bearable arms falls completely outside the Second Amendment's protection, directly contradicting everything the Supreme Court established in recent landmark decisions. This creates a devastating reality for gun owners in Illinois, Indiana, and Wisconsin. If you live in these states, your short-barreled rifle has no more constitutional protection than a hand grenade or a nuclear weapon. Meanwhile, gun owners in Texas or Montana enjoy completely different rights under the same constitution.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
Government may not regulate individuals' possessions of weapons for self-defense.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
My response to that is that's the same claptrap that they have been using for 20 years.
Your zip code now determines your fundamental rights, and the Supreme Court just said they're fine with that. The story gets even more bizarre when you discover what the new administration did behind closed doors. When these cases first reached the Supreme Court, something unusual happened. The Department of Justice initially waived their right to respond, a move that typically signals the government won't defend a challenged law. Gun rights advocates celebrated, thinking the new administration would let these unconstitutional restrictions die quietly. Then the Supreme Court did something almost unheard of. They ordered the DOJ to file a response anyway, essentially forcing them to take a position. When that response arrived, it stunned everyone. The administration that many expected to champion gun rights instead argued forcefully for denying these cases. They didn't just suggest the court pass on these particular challenges. They mounted a full-throated defense of the National Firearms Act's restrictions. Their argument revealed a calculated strategy that few people understand. The DOJ claimed these short-barreled rifle cases aren't the right vehicle for addressing Second Amendment issues. Instead, they urged the court to focus on state-level assault weapon bans, specifically pointing to challenges against Illinois's AR-15 prohibition. This strategic positioning suggests something profound about how the administration views federal versus state gun control. They want to preserve federal power while attacking state restrictions. To understand why this matters, you need to know the dark history of the law at the center of this controversy. The National Firearms Act wasn't created to stop crime or protect public safety. It was designed in 1934 as a backdoor gun ban using Congress's taxing power. Unable to ban firearms outright due to constitutional constraints, lawmakers imposed a $200 tax on certain weapons, equivalent to about $4,000 in today's money. Here's where it gets interesting. Short-barreled rifles weren't even the target of this law. Congress originally wanted to restrict handguns, but fierce opposition forced them to remove pistols from the bill. They kept restrictions on short-barreled rifles and shotguns only because they feared people would cut down rifles to circumvent a handgun ban that never happened. These weapons remained restricted by historical accident, not deliberate policy. For 90 years, this $200 tax hasn't changed despite massive inflation. What was once prohibitively expensive now costs less than a tank of gas. Yet the bureaucratic nightmare remains. The ATF processes over 500,000 applications annually, with wait times that can stretch beyond a year depending on political winds. This system persists not because it prevents crime, criminals don't file paperwork, but because it generates control and revenue.
They really don't know what to do with this one, which is always a good thing to see.
This case could reshape how far states can restrict your right to carry and wear.
Aimed at declaring various federal gun restrictions unconstitutional in the state.
Red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better.
Major decision from the Supreme Court that could have larger implications on gun laws nationwide.
Now here's where this story takes its most dramatic turn. Buried in recent government funding legislation was a provision that accidentally set the NFA tax to $0 for certain items. This wasn't some victory for gun rights, it was a technical budget fix that nobody paid attention to. But this seemingly minor change might have accidentally destroyed the entire legal foundation of federal gun control. The NFA survives constitutional challenges only because courts treat it as a tax law, not a gun ban. The Supreme Court upheld it in 1939 under Congress's power to levy taxes, not as a Second Amendment issue. But if the tax is $0, what exactly is being taxed? You can't have a tax law that collects no revenue. That's just a regulation wearing a disguise. Multiple new lawsuits are exploiting this vulnerability, arguing that without its tax component, the NFA must face full Second Amendment scrutiny. Under current constitutional standards, these Depression-era restrictions would almost certainly fail. The government would need to prove that similar regulations existed when the Second Amendment was ratified in 1791, an impossible task since these weapons didn't exist then. The Seventh Circuit's ruling in the Rush case represents one of the most radical anti-gun decisions since the Supreme Court recognized individual gun rights. They didn't just say short-barreled rifles can be heavily regulated. They declared these firearms fall entirely outside constitutional protection. According to this court, the Second Amendment's text doesn't even apply to these weapons. This interpretation relies on a 1939 case decided without any defense attorney present before the Supreme Court recognized individual gun rights and during an era when courts viewed the Second Amendment as protecting only militia service. The Seventh Circuit essentially traveled back in time to resurrect legal theories that should be dead and buried, ignoring decades of Supreme Court precedent in the process. While denying these NFA challenges, the Supreme Court did something intriguing. They relisted two other major gun cases for the fourth consecutive conference. The Illinois assault weapon ban and California's magazine restrictions keep getting held over instead of denied. This unusual pattern suggests serious behind-the-scenes negotiations about which case to take. When the Supreme Court wants to deny a case, they just deny it. Repeated relisting indicates genuine interest from multiple justices. It takes 4 votes to grant cert, and this behavior suggests they're either close to that threshold or debating which case provides the best vehicle for a landmark ruling.
The Second Amendment protects the right to carry a gun in public for self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
Is a massive deal. It directly goes after the ATF's tactics over the last 2 years.
Basically, they kicked the ATF in the teeth. They seem kind of punch drunk. They seem as though they got the bell rung pretty bad.
When things sound really good for gun owners in court, that doesn't mean it's over.
The Illinois case presents particularly compelling facts. The state banned the most popular rifle in America, owned by over 20 million law-abiding citizens. Unlike the criminal defendants in the NFA cases, these plaintiffs are ordinary Americans who want to exercise constitutional rights for lawful purposes. The contrast couldn't be starker. Soccer moms and veterans versus someone caught fleeing from police. Since the Supreme Court's 2022 Bruin decision, lower courts have created absolute chaos in Second Amendment law. Some courts faithfully apply the new standard and strike down gun regulations. Others essentially ignore it and uphold any restriction they would have approved before Bruin existed. This inconsistency means your constitutional rights depend entirely on geography. The Second Circuit upholds virtually every gun regulation using creative historical interpretations. The Fifth Circuit strikes down similar laws, finding no historical support. The Third Circuit cites colonial storage requirements to justify magazine bans, while the Ninth Circuit calls those same examples irrelevant. Federal judges are literally making up constitutional law as they go, and the Supreme Court's silence enables this chaos. Three scenarios could unfold over the next year, each with massive implications. First, the Supreme Court could grant cert in the assault weapon or magazine cases, potentially establishing that commonly owned arms like AR-15s receive full constitutional protection. Such a ruling would cascade through the legal system, undermining the NFA and similar restrictions. Second, the court could continue denying all major gun cases, allowing the circuit split to fester. This would entrench a system where Texans and New Yorkers have fundamentally different constitutional rights despite living under the same constitution. Political pressure would build for either congressional action or eventual Supreme Court intervention, but resolution could take years. The third scenario involves those $0 tax challenges working through lower courts with a stronger legal theory than these failed cases. If courts accept that the NFA no longer functions as a valid tax law, the entire federal gun control framework collapses. There's simply no historical tradition supporting registration and taxation schemes for commonly owned firearms. The Supreme Court's next conference in 3 weeks will reveal whether those assault weapon cases finally get heard or suffer the same fate as these NFA challenges. The justices' decision will signal whether they're serious about enforcing their own Second Amendment precedents or content to let lower courts openly defy them. What happened today represents more than just 2 denied cases. It's a fundamental question about whether constitutional rights mean anything when courts refuse to enforce them. The Supreme Court had the opportunity to restore clarity and consistency to Second Amendment law. Instead, they chose silence, leaving millions of Americans in legal limbo where their rights depend on which judge they draw and which state they call home. The battle for gun rights now shifts to different courtrooms with different strategies. But one thing remains certain. The chaos will continue until the Supreme Court finds the courage to enforce its own decisions or admits that the Second Amendment has become nothing more than words on parchment, subject to whatever interpretation hostile judges prefer. That's it for today, folks. See you in the next video.